Okay, so I'm sure that most of you we have seen each other already earlier today, but still good morning, good day, and good evening in whichever time zone you have joined us. Hope you're all fine and enjoyed yesterday's as well as today's meeting. You should be aware that now you will be part of one of the highlights of this FIATA week this year. So welcome to the session, High-Level Dialogue on the FMC. And again, it's an honor to have with us today the US FMC Commissioner, Ms. Rebecca Dye. And I would like to once again thank her for taking time out her busy schedule to be with us today. So once again, good morning, Commissioner Dye. It seems that we have a regular Tuesday breakfast morning session in these days because we had a meeting last week on the Working Group C.
Very enjoyable.
Thank you. Yeah, Commissioner Dye, you are a well-known and highly appreciated public person, and we all have sure read plenty of articles featuring you, but allow me still a few words of introduction. It was President George W. Bush who had the honor to nominate you as FMC Commissioner in 2002. And since then, you have been renominated on a few occasions by President Bush as well as by President Obama. But also prior to your appointments to the FMC, you've been close to maritime transport with an extensive background in various functions. Let me just add that your work related to the fact-finding 28 and the concluding final rule on demurrage and detention earned you a lot of respect and appreciation in our industry. And this is well across national borders of the USA. It's on a global scale. And in this context, of course, investigating is one thing, but doing it with so much dedication, thoroughness, and focus on details is really, really impressive. And as you know, FIATA has taken the FMC final rule to develop the FIATA toolkit on the final rule. And this toolkit is intended to help other regions and countries globally in their exchanges with their national regulators to argue their cases, as unfortunately government authorities are not always as hands-on as the FMC and you have proven to be. But let me also say a few words about the FMC and its objective. The FMC is an independent expert agency charged with regulating liner shipping in US trades. And from its interceptions in 1961, and yeah, 1961, I have to add a few things. Number one is the year I'm born, and number two, it's an excellent Bordeaux vintage. So the FMC has worked to further its mission to ensure a competitive and reliable international ocean transport supply system that supports the US economy and protects the public from unfair and deceptive practices. I got that from the web page. So in a nutshell, the FMC's goal is the protection of American exporters and consumers against unfair practices. So in this meeting, we will need to talk about the disrupted maritime supply chain. Decades of globalization and free trade policies have made the world and their economies interdependent. And there's no turning back if one wants to ensure continuous global wealth creation. However, unprecedented developments related to the pandemic have brought the maritime supply chain to its knees. The reliability is on its lowest level ever. There's many stakeholders and the global economy as a whole have been negatively affected. There's a lot of frustration and emotions at hand. The reasons that may lead to the situation are complex, numerous, and in most instances lack transparency. But dear Commissioner Dye, we look forward to hearing from you about the disruptive maritime supply chain and related developments in the USA. And in this context, also get an update on your investigations related to the compliance with the final rule, as well as fact-finding 29. The session is called High-Level Dialogue on the FMC. So the focus is on dialogue. We want a lively and active exchange, a true dialogue. So before we start, let me briefly explain how you are supposed to participate, not you, Commissioner Dye, but the audience, to participate in this meeting. So first, Commissioner Dai will present her speech that is expected to entertain us for about 20 minutes. And already during this speech, you are encouraged to ask questions by using the question and answer chat function of the Zoom module. At the end of her speech, we will then immediately go into question and answer sessions that I will moderate. So with the help of Angela, with the help of Andrea, of course. So Commissioner Dai, the floor is yours.
Thank you. Thank you for that. And yes, I'm always pleased to have a chance to speak to your very well-regarded membership. I want to take a time to recognize, in particular, my friend and colleague, Richard Gluck, who has always been a huge help and advisor to me. So here we are. I talked to one of our major ocean carrier CEOs just yesterday, and they don't know what the rest of the year will bring. This explosion of international cargo was unexpected in volume and time, certainly by the FMC. In 2010, I conducted my first this is my fourth major investigation. I conducted the first one, and if you remember, at the end of 2009, just at the end of the global mortgage crisis, demand fell out. We had over 500 container ships tied up worldwide, and some ship operators were carrying cargo Asia to Europe for nothing, simply to keep the ships operating and avoid tying them up. At the beginning of 2010, importers in the United States, some all over the world in certain cases, decided to restock all at the same time. And so we had a situation that we thought at the beginning last spring that was much like 2010. It resolved in 2010 in a few months, and so that's what we expected. But that's not what we got. The problems that we are seeing, port problems, the supply chain dislocations, are not new. But the results, because of the length of the volume of cargoes, the results have been extreme. I started the investigation just about a year ago, this time in 2020. We had also released the demurrage and detention rule previously. And so we took all of these things, put them together in my fact-finding 29, loosely addressing the pandemic, more particularly addressing the problems that always result when the system is stressed. I started talking about the supply chain and the supply chain as a system in 2014, after concurrently with the huge dislocation in our major gateway, Los Angeles, Long Beach, largely because of labor slowdowns. And I began to talk about the system. Decisions made upstream can have negative consequences downstream. I talked before a group in Maritime Week, actually twice, in Copenhagen. And I ran a working group there, and there was a dozen, very few Americans were there. It was largely an international office attendance. And my part of the presentation was about infrastructure needs in 2030. We had a 1-hour session. We talked about 15 minutes. The conversation was relaxed, but it began to trend down. And so I said, let's talk about something else that interests me currently. Let's talk about the supply chain. Everybody in that group came alive. They all sat up, they leaned in, and somebody, many of you probably know, said, well, first of all, we need to get rid of the bottlenecks. I said, well, that's the idea. And since then, I've been running what we call FMC innovation teams, and they're all built around this concept. It's a system. Everything has to do with everything else, and simple discussions are not going to work. No more talk. We want action, focused on one problem at a time. And the people who have done it love it. I use that to refine our approach on demurrage and detention. And it gives government agencies just that little bit of assurance when you've developed what you think is a good approach in public policy. And it also can produce fabulous breakthroughs for supply chain problems generally. As I said, the problems that we're seeing now are not new. They are having a worse impact because of the length and the depth of the problems. And I have to take a breath when I say this, because I hope that I'm wrong, that many people believe that we will go right into our Christmas peak season in the United States. It's, end of July, August, and extend to Christmas, because we may have one of the biggest Christmases ever. So take a breath. I want to get to fact finding 28, demurrage and detention, and the fact finding, the investigation that I'm conducting now. A little background: when I started the investigation, as I said, we assumed that we would have 2 months and then we'd get back to our business, which is attacking problems one by one. As we know, that didn't happen. We did identify 4 main problems. One of those is the problem with container returns, which we carried forward into an order that I'm using currently to do some more intense work about. We also have a huge concern in the United States over the availability of containers for exports. And I have a call tomorrow with several members of Congress about that issue and about their concerns on that point. The commission gave me a supplemental order to enlarge my authority, my investigations authority, last November. Since then, we have looked and encouraged shippers to send to us their problems, especially their problems on demurrage and detention, non-compliance. We have yet not received any shipper authority to proceed with an investigation in their names using the fact situations of their complaint. As you know, the United States did not prohibit all demurrage and detention charges. if a shipper, and I had not one shipper tell me he shouldn't pay in situations in which he keeps a container too long, or a shipper who fails to pick up cargo or be in a position to pick up cargo within 3 days. And so if the system is misused, then charges are appropriate. Charges are not appropriate in situations in which they are used systemically to push off the consequences of port congestion on to shippers. The people who are in the least, the worst position, I should say, to make a change to the system to make it run better. Our approach is, you may not charge, so let us help you work together to fix the problems, which will benefit everybody: carriers, ports, intermediaries, shippers, truckers, and that's our position, and we continue to advocate that. And were it not for the pandemic and our virtual meetings, we would have had, I believe, much more success in getting all of our ocean carrier CEOs in one room and saying, this is going to happen. And what are you going to do to make it happen? So right now we have what we call a Section 15 order. It's one of our largest FMC law enforcement hammers, because we're concerned that there is not an industry-wide compliance with our demurrage and detention rule. In other words, there are charges being levied against truckers, shippers, in situations in which they're not only not prepared, they are directly prohibited from returning equipment or picking up cargo. And so, although we don't have a complaint with authority from a shipper, I believe we have another approach that will be effective in making our point that the compliance is not voluntary. We're also going to be looking at the practice of container availability and for exporters and the process of container return in the ports. But the key to all this, and the key to the pain, although the exporters are having a huge problem with container availability. It's a country, containers go to population centers, not necessarily where they're needed, and relocation costs are exorbitant. And of course, ships weigh out. Exports are heavier. And so usually to keep the ship loaded, balanced, there are some export containers that are loaded on a ship going back from the United States. There are some containers that are loaded empty. Whether or not there are, that's always the reason, or there are other reasons that we're investigating right now. But the main focus, as I said, the main pain point are these enormous demurrage and detention charges. I had a conversation with our chairman yesterday about some, and my other colleagues as well, about some of the recommendations that I'm going to make. One of those is we're going to run a clinic for people who have not really been able to get their money back, and for charges that are unreasonable. And we're discussing about how to do that. Certainly, we want to provide our ocean carrier partners and our ports with all the due process to which they are entitled. So that's there are quite a few other recommendations, but we're still forming those up. I think I'm not exactly sure actually what the date is that we released the information demand, but we gave the terminals in LA Long Beach and New York, New Jersey, our two major gateways, and ocean carriers and alliances that serve both of those ports. Most of them do. I think we gave them 60 days. But we're having discussions now about what we want to see in the responses, and so we should be ready to congratulate those carriers who are in compliance. And there are some, and they call me for clarifications about the rule. Many don't. So that's where we are today. It's a privilege to speak to you, and I'd be delighted to hear your questions. Thank you.
Yeah, thanks so much, Commissioner Dye. I think you mentioned the possibility of the biggest Christmas shopping ever. I mean, I think Congress just approved the 1.9, is it trillion? I don't even know how many zeros package.
I think you're right. It's hard for me to conceive, but I think you're right.
So I mean, so the consumption is not going to stop, and this is the world we created. So and if right now is already a question, okay, how are we going to solve the problem? And it's basically rien ne va plus. It's really difficult. There does not seem to be many ways out. So it's going to be really interesting how this is going to develop. You mentioned, if I'm not mistaken, that there has not been any official complaints about compliance or non-compliance of shipping lines.
We have many, which we appreciate because it helps inform us about what to do. But it's very it can be intimidating for certain shippers to put their names on a particular fact situation. Yeah. And without that, it's very hard. It's hard to get more information because obviously the carrier will say, well, wait a minute, we've got records and everything, but who is this? And much of the information, as in all disputes, much of the information is in the hands of the other party. Mm. So without a name, it's hard for us to have a full investigation. And of course, nobody really, to tell the truth, what I want, there could be enormous civil penalties from non-compliance in situations like this. My interest is not so much that. My interest is just compliance. Mm. Let's all observe it, and then people want their money back, right? So that's my focus right now.
So, a related question. So, if there is a party who believes that there's a non-compliance involved, what would be because right now, I mean, I have the impression that shipping lines are quite relaxed about the final rule, also in their applications is yeah, it's everybody's mistake. But so what would be the process the FMC would follow? What would be the tools the FMC has?
What are we going to do? I'm not going to say yet. I'm not going to say yet. It's part of the investigation, and I think that we can bring them into line. The approach on demurrage and detention was the first of its kind. We have never done a rule around the statutory requirement to observe and maintain reasonable practices. So this is the first time ever. And so for us it's new too. The rule, as you know, and I use your toolkit, by the way. It's wonderful. So thank you for that. If I failed to mention. But it's, and I don't know, actually, in their defense, I don't know what legal advice they've received. I don't know. But I think that despite not having a complaint, I believe that we have an approach to get attention and to get everybody pulling in the same direction on this. I received a request for a webinar yesterday from the Australian shippers. My friends at one of the major maritime publications tell me that they believe that the Europeans, that the Chinese would like to follow suit, but how to do this? They don't have a shipping act. How would this happen in those within those international legal systems? And I don't know.
Yeah.
But we welcome because to have, as we know, these charges are as old as little green apples.
Yeah.
And so to have more international push would be beneficial.
I think this was a dialogue, and the global context is a good way for the next question. Does the eventual finding of the FMC overlap as it effectively applicable towards line carriers anywhere else outside the USA, or are there indirect measures to assist us later? So basically, what do you believe would be the international context? And to combine that with another question, how is your dialogue internationally with, for example, the European Commission, with Chinese, Australian, South African authorities? What kind of dialogue are you in there?
We're just beginning to explore that. In fact, I got just yesterday, I got the inquiry from the Australians. We have had a touch, I should say, an expression of interest to talk from the Chinese, and our State Department is following up on that right now. So I'm delighted by that. The real challenge here with port compliance and demurrage and detention is that for this to work seamlessly will require a complete overhaul of IT systems in every port and terminal, probably to interface with ocean carriers, because all these millions and millions of boxes have to be tracked, because there will be some that are returned too late, and some that can't be returned on time. And so, and I'm not aware of there is any system, IT system, that would handle that, that's available now. And we knew that. We knew that when we, in fact, had discussions about that. I said, we can't do it. We can't do that. I said, well, you're gonna have to comply in some way.
Yeah.
Because you cannot charge off congestion.
Yeah. Yeah. There's one question, taking into consideration the shipper or consignee fear of intimidation by carriers to lodge a complaint, would there be alternatives? So obviously, if you depend, particularly for the next 2 years, I believe that shipping lines will remain very much in the driver's seat. So if you want to ship your cargo, if you want to serve your customer, you have to be in good terms with
Yes.
with your supplier. So would there be
Yes.
alternative ways to lodge a complaint without being having the risk to be intimidated?
Yes, yes, and we understand that. These are not new concerns, and we get that. As I said, we're working on something right now. Okay? Hopefully that can respond and to help get your money back. We also have a very well-regarded consumer affairs, sort of a dispute resolution office. And a lot of people are dedicated to them because they work very hard and they're relentless in pursuing accommodations in certain areas. Much to my concern, I have heard recently that at least one ocean carrier refused to engage with our dispute resolution staff. And I've never heard that before. And I have to say, I'm not happy to hear that.
Another interesting subject that came up when we met last week with Working Group C. Could you imagine that the FMC final rule, the document, becomes a certain standard? Because I remember in the meeting last week, we talked about putting compliance to the FMC final rule possibly into contracts, future contracts. So could you imagine that it could be a kind of a standard for certain contracts, possibly also globally?
Yes, and in fact, I've spoken to several shipper groups, their trade associations, large and small, and I have advised them that when you're sitting down to sign a contract with an ocean carrier, if you don't raise this issue with them, if you don't say, do you comply with the FMC's rule on demurrage and detention? If you're not satisfied that the answer is yes, you need to be just as concerned about service as you are about price. You're missing a huge opportunity to protect yourself. And although I don't give legal advice, I'm very careful not to. The FMC is not going to look over anybody's shoulder as they negotiate with their private arrangements with ocean carriers. It will help me a lot. And for the first time in the world, to make this change is probably the largest that the FMC has ever undertaken. Because it's a lot of money. There has always been almost taken for granted that the risk of port congestion should lie on the shipper, on the trucker. And we changed that. No, we don't agree with that. We agree that the risk is on you, on the people most able to make the change. So we need everyone to do what he can to emphasize that this is not voluntary, although the rule is called an interpretative rule, and there are many ways to comply in the rule. I don't think anybody has to do every single thing that we discussed. But at the end of the day, the requirement to observe reasonable practices is statutory. There's no way around that.
I mean, you sure have our support within FIATA to create a lot more awareness about the final rule and to possibly make it a standard. And you mentioned that it does not seem to be right to have to make shippers, forwarders, truckers responsible. But unfortunately, I mean, there are other oligopolistic behavior of shipping lines. I mean, you investigated recently the merchant clause at the FMC, and FIATA
Yes.
provided their thoughts on that. And
Yes.
there are further developments that if you pick up a container and you're not even party to the contract, but you have to sign agreements to become a party
Yes.
of the contract of
Yes.
carriage, which does not make any sense at all. So there are other practices. Another one is, of course, merchant haulage. I mean, for us freight forwarders, it's extremely important to be involved in the intermodal transport to offer merchant haulage. So there are developments from the shipping lines to use their strength, their power in the supply chain as a stakeholder, to put unjust practices on other stakeholders. And I mean, for the next 2 years, it is expected that shipping line will remain to be in the driver's seat, because you just can't get any vessels on the water. and unless you build them, which is a process of 2 years. So to wrap it up, so how do you see other developments of shipping lines trying to enforce certain contractual things on other stakeholders?
Yeah, we had a lot of interesting findings on with our original teams discussion published in 2017. And one of those was on billing. You bill the person with whom you are in privity of contract, not anybody else, not just anybody that you can describe in a bill of lading, or you can require to implead himself, because the system, when you look at the system, that is the cleanest and clearest way to resolve these issues. And the definition of merchant is one of those that I'm not sure if we've had a vote on an approach. And so we agree with you, especially on that, because it simply encourages more chaos in the system. Have a rule, clear rule, and stick to that. And that's just because it may be more convenient for you, or it's not convenient for the users of your services.
Yeah, I think at the end we have to look into the future, and we discussed it in our working group meeting that I mean, you mentioned digitalization, exchange of data, and I think there's a lot of room for improvement. One of the questions that also came up is that the pandemic helped to facilitate digital bill of ladings, container release at some ports in Latin America. However, shipping companies are starting to ask again for original bill of ladings. Can digital release be an obligatory procedure for safety and efficiency? I guess the future is in digitalization and data exchange. Goods bill of ladings have an important function. Originals will always be there, but I think the stakeholders will have to deal with it. Yeah, Commissioner Dai, once again, it's been an honor for me to have you with us today. And on behalf of FIATA, I would like to thank you. The maritime supply chain is on its knees. Its root causes lie in the past, and all stakeholders have to deal with the situation. But going forward, we will need a better cooperation amongst the stakeholders. At the end, we are sitting in the same boat. I really wish that the FMC and you personally, Commissioner Dai, will have the vision and tools to not only guide the industry into a reliable and resilient supply chain, but to also ensure a same level playing field of all the stakeholders, and you are aware of our concerns about that. But before we close the session, I would like to hand over to our president, Mr. Basil Peterson from Johannesburg, South Africa, because he would like to address you and thank you from this side. I don't know, Andrea, whether I surprise you now, or are you ready?
Thank you.
No, it's been a pleasure.
Good afternoon to you. Yes, it is almost afternoon for you. Still good morning, Commissioner Dai. It's an absolute pleasure listening to you, and it's an absolute, I think, on behalf of FIATA, to have you, address us in this forum. It would have been wonderful to have a stage where we could all see you and come up to you and have a chat to you afterwards. But,
Yes.
but as we know, times prevailing, we're unable to do that. But here we are. As humans, we putting it simply, we make a plan. But having listened to the discussion, etc., I think I've learned more in this period of time, as opposed to all the reading I've done and all the research I've done personally on the subject of FMC. Having been responsible for the association in South Africa, having my own company, and being involved in FIATA, I made it my duty to have a look at the FMC. But I must say that what has been happening, and I hope that all my colleagues and all the members on this session would have gotten the same out of this. What I would like to say to you is that we are actually honored to be associated with so much as esteemed as yourself, and also your department and your people who do such wonderful work. It is absolutely for us an honor to be there. There is always going to be a leader in something, and obviously you've taken the responsibility. You and your team have taken the responsibility to get working on these rules, etc. Yes, probably at the moment it might be for yourselves in America, but as you can see already, as FIATA has taken on this responsibility, it is now shifting, and it's now getting an international exposure, etc. And all we can do is encourage you to continue the good work and continue in other areas of what is needed. So yeah, without delaying anything, because I know the guys have got all sorts of other meetings coming up, let me just say to you that we are very, very, very happy and very proud to be associated with you, and we thank you tremendously for all the work that you've done, especially with our friends here, with Jens, etc. It is appreciated. So from FIATA's point of view, I thank you. Thank you very much.
Oh,
I
have to emphasize that these processes, and it's not written down anywhere. We just have to identify the people who know what they're doing and listen
Correct.
to them. And you're among those people, and I appreciate it. Thank you very much.
Thank you.
Good day.
Thank you very much. I'm sure.
Thanks again.
Thank you.
Thank you.
Cheers.
Thanks
Bye.
everybody for
Thank you very
joining.
much.
Thank you so
Thank
much.
you.
See you
Thank you,
later.
everyone.
Thank you, everybody. That
Thank
was
you.
really
Good day. I
Thank you.
appreciate your help.
Thank you.
Thank you.
Bye-bye.
Bye.
Bye.
Thank you.